Alex is
Oops,
coming.
see,
Good
I
morning,
muted
Alex.
myself. Good morning. Thank you, Elijah. Good morning, everybody. Thank you so much for joining us for the third and final installment of our Financial Resilience Workshop. Hopefully you enjoyed the first two. I know you're going to enjoy this one. We're very fortunate to have with us Janet Morris. She's an elder law attorney. Some of you have probably seen her presentations at our extravaganzas. And also she did the Purposeful Living Workshop last year. She's extremely knowledgeable, and I think what really sets her apart is she's able to take really complex information and break it down into very simple terms so that everybody understands. And I know you're going to get a lot of great information out of this presentation. Even if you've heard some of this before, you're just going to get a deeper understanding. I'm really excited to have her here. I hope you are as well. And again, like the other presentations, this will be recorded and available on our website after today. And then we will be emailing out everybody the PowerPoint presentation. So with that, I'm going to turn it over to Janet. Welcome, Janet.
Hi, welcome everybody. Thank you so much for inviting me again. It's really a pleasure to talk to all of you. And I hope you learned something new today if you've been with us before. And if you haven't, this will probably be new and a lot of information. So if you have questions, put them in the chat box. We'll get to them later. And if you have a clarifying question where you really don't understand something I just said, you can also put that in the chat box, and Elijah will get it to me during the presentation. So like Alex said, I'm an elder law attorney. I work in the area of planning for the future, estate planning, public benefits like Medi-Cal and Medicare, and elder abuse issues. And I've been doing this for over 33 years. I practiced at BetSedec Legal Services, which is a free legal services for low-income people in Los Angeles area for 30 years. And now I'm on my own and still doing the same thing and loving what I do. So we're going to launch into this topic because it is so important for everybody. And every day I get calls from clients or potential clients who are stuck because their loved one is showing signs of incapacity or in the hospital and needs some long-term care planning, and they don't know what to do. And we have to figure out all of the different tools and aspects, and if they have some or all or none, how we're gonna go forward. So it's a timely topic for everybody all the time, because my guess is not all of you have done your planning. So this is at least a point to start thinking about it, to start talking about it, and to figure out what to do next. So let's start. So who should plan? Everyone should plan, whether you're 18 or 81, whether you're healthy or whether you're health challenged, and whether you're married in a traditional relationship, a non-traditional relationship, it's super important to plan. And we'll talk about why that is. And then also, if you don't have many relationships, it's also very important to plan, because who's gonna take over if you don't really have any significant other that's around? So as you know, when you turn 18, you become an adult, and you have all the rights and responsibilities of an adult. So the fact about planning and putting something down in paper about who's gonna help you if you become incapacitated is really important, not just if you're retired or over the age of 60, but at any age, especially kids going off to college, something could happen there. And so they need to plan as well. So why plan? Everybody could get sick, everybody's getting older. You could lose capacity by tripping on the sidewalk due to a stroke, an accident, a hospitalization, COVID-19, many reasons why you could become incapacitated. You may be close by your family and friends, or you may be visiting somewhere else. You may be in the city, state, or country where you have no providers or friends. So somebody may have to help you. So the plan is to pick the people to help you, okay? And put it in writing and make it legal. And then again, if you don't plan, there's a risk that someone who you don't like or who you don't know, like a public guardian or a stepchild or someone, could step in and petition to make your decisions for you, and you don't want that. So if you take control now, you get to decide, and it lets you have control. And that's why we have to plan. So what are the kinds of things that I'm talking about? So the things that will help you during your lifetime are powers of attorney for finances, powers of attorney for healthcare, living trusts, and we'll go through what each one of these things mean because they're different and most people don't understand the difference. There's something called a transfer on death deed that you could do now. Bank accounts, you could title your bank account certain ways and name beneficiaries. You could prepare life insurance, buy life insurance for yourself that will help you, where you name somebody during your lifetime as the beneficiary. Disability insurance and long-term care insurance. And we're going to talk a little bit about those things as well. After death, what's going to help you? The will is not you, but it will take effect after your death would be the will, life insurance benefits, the living trust, and also the transfer on death deed, which should actually go in here. So I'll have to change that next time. Okay, we'll talk about those things. When should I plan? Right now. Every day, it's funny because every time I give a talk, I usually refer to a case I got yesterday that's relevant to today. And again, I have a client that I just called me this week whose husband has Alzheimer's and he's getting worse. She has cancer and they made their own documents. And when she read them to me, they're not useful. Okay, so I'm going to go over there after this to visit them and see if the husband still has capacity to make his plan and to sign the documents. And hopefully he will. And otherwise, it may be too late for him to do the right plan. So now start thinking about it. Start thinking about how you want to get these things done. So it's too late to plan if you're incapacitated. Okay, and also it's too late to plan if you're in a quarantine situation because nobody can get in or out of the hospital to help you sign those documents. We're going to talk about capacity and incapacity because it's not about having the diagnosis of Alzheimer's or the diagnosis of stroke. It's about what you can understand and not understand. And it's a pretty gray area when we talk about capacity and incapacity. So capacity to make decisions, it depends on whether you're talking about legal and financial decisions or health care decisions. And in California, and by the way, I'm talking about California law right now. There's 50 different states, 50 different laws. They're kind of similar, but they're not exactly alike. So when I talk about all of these different things, I'm talking about California law. I'm talking about the California Probate Code because that's what covers all of the things we're talking about today, like powers of attorney, trusts, wills, and capacity issues. And we have a law in California called the Due Process and Competency Determinations Act. And that's a long title, and you'd think it would be very descriptive about that the actual law would say what's capacity and what's incapacity. And it really doesn't help us too much because what it says is that you have capacity to sign a document as long as you understand that document at the time that you're signing it. So let's say it's a power of attorney and you go to an attorney to help you sign that document and the attorney asks you a few questions about what's your name, what's the date, you know, some capacity questions, who's the president, who are your kids, what are their names, if you can like explain those things, if you could say that, or it doesn't even have to be through verbal communication, it could be through nonverbal communication. If you understand those things and you can understand the document, like this is to give someone else the power to sign your checks and, you know, pay your bills and those kinds of things, or make your medical decisions. If you can understand those things at the time that you sign that document, that's considered capacity, okay? That, you may find that to be not correct because maybe 10 minutes later you forgot what you signed, okay? So there's a lot of issues around the elder abuse and undue influence and things like that that play into capacity. But the bottom line about this law says that you have to understand the thing that you're signing at the time that you're signing it. And it doesn't really matter if you've already been diagnosed with Alzheimer's, stroke, or whatever. That doesn't take you out of the running in terms of being able to sign something, okay? So because there's various, you know, stages, you know, various conditions, even with like developmental disability issues, such as autism. There's very slight to very severe. And can people sign documents? Depends on whether they understand the document. Now, also I wanted to say that you do not have to go to an attorney to do these documents. But I recommend, and not just because I'm an attorney, but because like my client who called me yesterday that I'm going to see today, they got their documents online and they did it themselves. And the key problem with the ones that they did is not the document itself. The document itself was fine, but nobody guided them. So they made their legal document husband and wife. So they did it together instead of separately. So the husband is incapacitated. So it's kind of a useless document. So I have to go back and do one just for the husband and do one just for the wife. Had they gone to an attorney, they wouldn't have made that mistake. Because when she told me about how that document was written, I said, well, that wasn't a good attorney that advised you. And she said, well, we didn't go to an attorney. So there you go. It may be worthwhile to seek legal advice on these things before you, you sign them. The other thing is that many times you don't get the right document online. So I don't recommend that you go online to get documents. I do not recommend that you go to like Staples or Office Depot because, excuse me, often they will have a bunch of documents in a sealed plastic. And from time to time, I go and buy one of those packets from Staples or Office Depot just to see what's in them. And sometimes it's a New York power of attorney, sometimes it's a durable, sometimes it's non-durable, and we'll get into what that all means and what you need. So I do not recommend that. As far as healthcare decisions go, the capacity required to sign a document, a healthcare advance directive, is different. It's a lower threshold of capacity than the capacity to make a actual medical decision. So the capacity you need to sign a healthcare power of attorney or advance directive is that you know basically what the document is. You're giving power to someone else to make medical decisions for you if you can't make them yourself. And you have to be able to communicate who it is you want to make your medical decisions for you. And then you may want to put in preferences like, you know, I want life-sustaining treatment or I don't want life-sustaining treatment at the end of my life. Whereas a healthcare decision, you have to understand your diagnosis, the treatment, the advantages and disadvantages of the treatment. So that's a higher level of capacity, medical decision-making versus capacity to make an advance directive. Okay. So the things that we're going to talk about now are surrogate decision-making tools. And a surrogate is somebody who acts on your behalf, okay? Like an agent, okay, or a power of attorney. Those are all the same names of people who are your surrogates, people who are acting on your behalf. So in surrogate decision-making, we have many tools that we're going to discuss. And the first one is called the power of attorney for finances. And I'll show you a facsimile of what a power of attorney for finances looks like. And you can see it's very simple. There's a line that says who the principal is. I, the principal is the person giving the power, Janet Morris. So the person giving the power has to have capacity, right? So the attorney who's helping you would decide whether you understood this document, or if you didn't use an attorney, nobody would be, there's no big brother out there watching you to see if you have capacity or not. So you could see how this could be used fraudulently, right? By someone who is a bad actor who wants to get your signature to basically get the keys to your kingdom. Because when you fill out this document, you're giving somebody a lot of authority. So I, Janet Morris, appoint, and let's say I appoint Alex. I appoint Alex Rabrinovich as my agent, okay, which is also known as an attorney in fact, okay, to act for me in any lawful way with respect to the following initial subjects. So you could see it's real property, that means buying and selling my house. Personal property, buying and selling all the furniture in my house. Stocks and bond transactions, commodity and option transactions, banking and other financial institutions. Alex can go to the bank for me and write checks and take care of my banking, deposit my checks, okay? Business operating transactions. If I had a business, Alex could do that for me. If I check, right, depends on what I check. Insurance, estates and trusts, beneficiary transactions, claims and litigation. He could file a lawsuit on my behalf or defend a lawsuit against me. Personal and family maintenance, pay for my caregivers. Benefits from Social Security, Medicare, Medicaid, and other governmental programs or military service. Retirement plans, tax matters, all of the above. So if you're planning for the future, which I'm talking about now, right? You don't need anybody to handle anything right now. You're doing it all yourself and you're doing it very well. For a future power of attorney, I would suggest that you put all of the powers listed above because you don't know what your agent is going to need to do for you. This is also a durable power of attorney. So that means it endures my incapacity. So when I become incapacitated, I want Alex to take care of all of my things, my business that I need to have done. And I want this to spring into effect upon my incapacity, okay? And this power of attorney will not stop just because I become incapacitated. So a non-durable power of attorney stops when you become incapacitated. A durable power of attorney endures through your incapacity. So you need to put into this durable power of attorney, this power of attorney shall, so this is the springing part, it takes effect upon my incapacity. So this power of attorney shall take effect upon my incapacity. My incapacity shall be determined by my primary care physician in writing. So we put this in there so that Alex has to at least get a letter from my doctor before he goes to the bank with my power of attorney to start using it, okay? Or if you're taking care of your elderly mother and you've already been doing everything for her already, you may want to change it for her purposes, her power of attorney to this power of attorney is effective immediately and will continue until it is revoked, okay? And by the way, all of the documents I'm talking about today are revocable. So if you change your mind, you can revoke that power of attorney and give it to someone else, all right?
Janet, may I interject? There's a clarification question that came up.
Yes.
And it says, please ask again about the difference between durable versus non-durable and how long it is in effect.
Okay, so durable means if you become, if it's in effect, okay, you make a power of attorney and it's in effect right now. You become incapacitated. It's still valid. If it has the magic language on here that says, this power of attorney will continue to be effective even though I become incapacitated. That is durable language. A durable power of attorney must contain that language. So if I have a power of attorney, I become incapacitated, it stays in effect. If it doesn't have that language, it stops when you become incapacitated. Okay, now, I want to make this a springing power also, which means it's going to go into effect. It's not effective now. It's going to go into effect when I become incapacitated. And that's when I write, this power of attorney shall take effect upon my incapacity. Because I don't want to give Alex anything right now. I want to write it today because I have capacity today. I want to write it and I want to say, Alex, I love you, I trust you, but I don't want you handling my business now. I want you handling my business if and when I become incapacitated. All right? So it will say the top line, and this document will also say the bottom line, which is this power of attorney will continue to be effective even though I become incapacitated. That makes it durable. Then I sign it, I date it, and I give Alex a copy for future use. He's not going to use it now because he can't use it unless he gets a letter from my doctor. Okay, so that's what we call a springing durable power of attorney is. That's what I recommend for future planning. If you're taking care of your elderly mother, then I would say it should be an immediately effective power of attorney that's durable. Okay, and you can revoke this at any time. The key point of revocation of this document is you must give a notice to your agent that you're revoking it in writing. So if I give Alex a power of attorney and then I decide, you know what, I really don't want Alex, I'd rather give it to my sister, I put in writing, I revoke the power of attorney I signed on June 24th, 2020. I have to not hand deliver it. I have I would deliver it certified, return receipt requested by mail to Alex, so I have proof that I mailed it to him. And then he knows he can't use this power of attorney now or evermore, okay? So if Alex, let's say Alex has already been using this power of attorney because I gave him an immediate power of attorney and I wanted to revoke it. I would have to give it to Alex, and then I would also want to give a notice of revocation to every place that Alex has used this power of attorney, Bank of America, with my retirement board, or whatever. So it's good to know who your agent is using this power of attorney with. You may not always know that, but to the extent that you do, you would want to send notices of revocation to them as well. Okay, we got to move along. So more tools in the toolbox. Bank accounts, so there's different kind of bank accounts. This is very, very important. Okay. Many people put their loved ones on as a tight owner of their bank accounts. Like husband and wife, it's no problem because in California we have community property. But what if we have a joint account with our daughter or our son? That is problematic. You don't do that. I would say you shouldn't do it if you want to use it as a planning tool for someone to step in when you become incapacitated, okay? Because what you're giving them by putting their name on the account is ownership of the account. So if you have $100,000 in an account that says mother and daughter, okay, the daughter can take the $100,000 out of the account because she owns the account jointly with you. Okay, she doesn't have to ask your permission. It's not elder abuse if she does that. She could go take that $100,000, buy a Mercedes, and not have any consequences because it's totally legal. If you want your daughter to help you with your banking, you can either give her a power of attorney account. Okay, so either take a power of attorney and give it to the bank. She could take a power of attorney from you and give it to the bank. Or she could sign a power of attorney card. You could have her sign a power of attorney card at the bank, all right? And that way she doesn't own the account. She can just manage the account for your benefit. By the way, all of these surrogate tools like powers of attorney on the bank account, like a power of attorney for finances, the person, the agent who's has the power that you've given them has a fiduciary responsibility to use that money for your benefit, not for them. So they cannot make a gift to themselves unless you specifically say that in the power of attorney. So a power of attorney on your bank account or a power of attorney document, they have to use your money for you, not for them, okay? Otherwise that's stealing. But if you give somebody title to your bank account, if you put their name on the title, then they own that money. Even though it's not theirs, even though you put the money in, they could take it out. Okay, so let's say you say, okay, I want to put Alex as my power of attorney on my bank account, and I also want to give it to him when I die. So in that case, I would do a power pay on death. So make him a beneficiary of that bank account as well. Otherwise, that bank account would go into probate with everything else through the will. Okay? And then he wouldn't get it. My heirs who are in my will would get it. So pay on death card at the bank means that you're assigning a beneficiary to that bank account only, and it goes outside of the will. All right. You must consider each of these things very carefully, and I'm sure if you had questions at your bank, the banker could explain them to you as well. Now, what do we do? There's another tool for Social Security and veterans benefits. And when you become incapacitated and cannot manage your funds that are coming through Social Security or veterans payments, your loved one can ask Social Security to become your representative payee, and then they can manage those payments, those income payments that come monthly from Social Security. So it's a way to start managing somebody's money who can't because they have dementia or their stroke or some other reason why they can't manage their payments anymore. And let's say they're going direct deposited into the account and the person is incapacitated in a hospital somewhere, and there's a need to get that money to pay rent and other things. So somebody can apply for representative payee to Social Security. It's fairly quick. Like within 30 days, you could get the rep payee, even sooner. I just had a client who did it, and within 3 days, they got the rep payee because it was an emergency. The mother was in the hospital and she needed to pay the bills. So the daughter became the rep payee and started getting the money herself in her name for her mother. So it's a surrogate relationship. So she's the agent of her mother by receiving it as rep payee and pays the mother's bills. She doesn't, it doesn't go towards the daughter's taxes, and it doesn't, do anything negative to the daughter. It's just she's taking care of the mother's money and she's paying bills with it. She opens a new account in her name for her mother. Was there a clarifying question on that?
There was one question earlier, sort of an umbrella question, that there's a lot to remember. Do you have an estate planning checklist? Is there any resources that maybe at the end of the meeting you can guide?
Well, I think this recording will be helpful. I don't have an estate planning checklist. I might be able to, you know what I do? Lacers has one. I think we did that last time around. I'll check with Alex and we can send that out to everybody. I think there is one, actually. Okay?
Okay.
Thank you. Let's go on. Living trust. This is another way to manage your affairs and to plan for managing your affairs in the future should you become incapacitated, and even now while you're alive. So, and also after death. So a living trust is a means by which you change the nature of all your property from owning it yourself to the living trust owning it, for the purpose of managing it during your lifetime if you become incapacitated, transferring it on death without a probate, okay? And giving your heirs their inheritance after death. So a living trust is a document that an attorney creates for you, which is going to hold all your assets. And it's going to change the nature of ownership of your assets from you as an individual, Janet Morris, to the Janet Morris Trust, okay? And I go to an attorney to make my trust. He's writing all these pages and documents, this assets, okay? And the of this and how it's going to work. However, can you hear me? Because I got a message that I was unstable. You're okay?
The connection's a little wobbly for a moment.
Okay, so the trust is going to hold my assets, but the way the trust holds the assets is I actually have to transfer the assets into my trust by writing a deed that the house belongs to Morris. I'm going to make a deed and
We're having some connection issues, Janet. Maybe we should just, let's see, move a little slower. It's just a little lag coming in.
Okay, so the trust has three parts. It has the trustor, the person who is creating the trust. That would be me. It has the trust, which is going to hold all of my assets. It's going to have the trustee who's going to manage the trust. It's also going to have a successor trustee in case I become incapacitated, who's going to manage the trust. And then it's going to have the trust beneficiary. So while I'm alive, now, 2020, trust or
All right, we're in a lag still.
uh-oh. Slow. Well,
It's a Wi-Fi connectivity issue. So while everybody's waiting for Janet to see if she clears up, we can so far put some questions in the chat section, and we're going to start asking them. And if we have a tough questions with a tough issue with the connection, we'll begin our Q&A earlier. Are you with us, Janet?
can you,
You're in and out. You're in and out, but try talking now, please.
do you have any suggestions?
Okay, we have lost you for a moment, Janet. Stephanie? All right, we're going to go and look through some questions over here.
And while you're doing that, I'm going to text Janet the dial-in, so maybe she can dial in from her phone. So at least we'll have her through audio.
Okay. Very, very good. All right, we're going to ask a couple questions. One of the first people I'm going to have up over here. Janet, are you with us?
Yes, I am.
Oh, okay. Sounds a little better. Let's continue on, and if we
Okay.
get it to happen again, we'll start with Q&A.
Okay, so the trustee, let me know if you want me to stop. The trustee is the person who manages the trust. I don't know what's happening here. The successor trustee jumps in if I become incapacitated. And while I'm alive, I'm the beneficiary. I'm the one who's living in the house, using my bank accounts, etc. But if I become incapacitated, my successor trustee takes over and uses all my assets for me. When I die, the beneficiaries are my kids. So then the successor trustee would, without going to probate, distribute my estate after paying my creditors, distribute my estate to my heirs. And it avoids probate, which is very costly and time consuming to get your assets to your heirs. So I'm going to move a little quickly now. Once you have your trust, keep it where others can find it. It's usually in a 3-ring binder. Just yesterday, again, that lady who I'm talking about, she didn't even know, she said she needed somebody to do a power of attorney. She didn't even know that, first of all, she didn't think she had one. Then when I said, have you ever done an estate plan? She said, yes. I said, is it in a 3-ring binder? Is it on your bookshelf? She said, yes. I said, go get it and read it to me. And that's how we found out that it was a terrible power of attorney. But you deposit box, because nobody can get it when they need it from you because you're incapacitated or you're deceased. And nobody has that key. So make sure that you share its existence or contents with the possible beneficiaries. You don't have to tell, you could just say, if something happens, open this envelope, or them if you trust them enough to know what's in your estate plan, or leave it in a file that's easily visible, or again on the bookshelf. I'm afraid right now that with everybody doing PDF and internet stuff, there's not going to be 3-ring binders on a bookshelf anymore, and people are not going to have the ability to find your trust when you die. And a lot of times attorneys go out of business or pass away themselves and they can't be found. You should also look at it every so often to see, are the agents still the agents? Do you still want those beneficiaries? Especially when somebody's born, dies, or gets divorced. And amend it as necessary and use a reputable attorney. Okay, so that's the quick and dirty about trust. And I know there's going to be a lot of questions and we can answer them later, but I want to get through everything so that we have a basis from which to talk. So one more thing about, you can revoke your living trust, and also you should have a living trust, especially if you have a house and some other assets, besides things that just have a straight beneficiary, because anything that you've named a beneficiary, like a life insurance policy, that doesn't go into the trust. It goes directly to to your beneficiary on death. So what is a will? A will is another way to transfer your estate to your heirs upon death. A will has no power in life, okay? When I ask people if they've done any estate planning, they say, oh yes, I have an executor. Well, an executor is just the person who's gonna take care of your will and do a probate and do the distributions of your assets on death. An executor has nothing to do with you in lifetime. So they're not the agent under your power of attorney. They're not the trustee of a trust, okay? So a will is only effective on death. Now, you still need a will even though you have a trust, because there may be things that are not in the trust that still have to be transferred to your heirs on death. So you need a will, a trust, a power of attorney for healthcare, and a power of attorney for finances in your estate plan. There are 4 types of wills. The first one is the prepared will, where you go to the attorney and he writes up the will for you, and you could disinherit people if you want. You can make you can disinherit people, you can give money to charities, all kinds of different things. That's the normal way that an estate planner in your 3-ring binder would have a prepared will in there. The statutory will is a form will, and it exists in the probate code, okay? And you could copy it, or you could go to a form. There's California forms that you can find, Walcott's forms that have a statutory will, and you fill in the blanks, okay? And the key about the statutory will is number 5 in there says, "At the rest and residue shall go to." It sounds like a throwaway thing, like I give my house to this person, I give my car to this person, and the rest I give to X. Now, that's not a throwaway thing, because by the time you die, you may own many, many more things than the house and the car. So the rest and the residue section, really, it could be the bulk of your estate. So you don't want to just say, oh, it goes to the SPCA if you don't really love the SPCA and that's not your main beneficiary. If it's your kids are your main beneficiary, you want to make sure that the rest and residue go to your kids, just like everything else, okay? So then you sign and date it. You have 2 witnesses. Also with the prepared will, sign, date, 2 witnesses. All have to be in the same room at the same time signing this will. The third type of will is called the holographic will. And the holographic will is something that you write in your own hand, and there's nothing printed on the paper. It's all in your own handwriting. So you can say on this piece of paper, I could write, I, Janet Morris, am preparing my last will and testament. I give everything to Alzheimer's Los Angeles and nothing to my children. Janet Morris, dated 6/24/20. That supersedes all my other wills, and Alzheimer's Los Angeles would be the beneficiary of all of my estate that's not directly given to beneficiaries elsewhere, okay? So maybe I have a bank account with a beneficiary named, or that goes directly. But everything else in my estate that's not in the trust, does not have an actual beneficiary and is not in the trust, would go to Alzheimer's Los Angeles. Now, that may be a lot of money. It may be a little bit of money. I don't know. Okay, it depends what kind of assets I have. If my house was not in the trust, that would mean it would be my house. Okay, so what would my kids do? They would sue in probate court as that they would say that they must have unduly influenced me or something, and it's not a true will, and they should go with the previous will. And it would be up to a court to decide whether I really meant it or I didn't, but I would be dead. So they'd have to use evidence from people. Let's say I was just doing it as an example, right? And this recording would be evidence in a will contest case that my kids would bring against Alzheimer's. So very interesting cases. I loved this part in law school. because there's so many like weird things. You couldn't even like make this stuff up that happens. You know, sometimes people give their dog everything and then the kids get freaked out. But depending on the circumstances, it could go either way, depending on the judge, etc. So that's a holographic will. It takes no witnesses, just sign, date in your own writing. And then if you have no will, you die intestate. That means no will. And all of these wills, whether it's prepared, statutory, holographic, or no will at all, has to go to probate. Okay, so there has to be a probate, which is a case opened in probate court. And it takes a long, long time, and it costs a lot of money because your executor who manages your probate gets a percentage of the estate. Let's say, depending on, you know, if you have $10 million, that might be like 15% or 10% of your estate. I'm not exactly sure, but it's written in the probate code. And then your lawyer for the executor would get another 10%. So it's double. All right. So it's very costly, and it takes more than a year to get this done. So,
all right, Bennett, I'm going to step in just because we are at the 2-minute warning sign, and we have questions for you after that.
2-minute warning for everything? Because I have a whole other section.
Okay, well, we're there so far, and Stephanie, please step in. We have 2 minutes to wrap up, and then we have several questions, or we can go on and finish your presentation.
Okay, I'm going to finish, and then we'll have less time for questions, but I can extend my time for more questions after if anybody wants to stick around. I'm sorry that we got slowed down here. So there's a transfer on death deed. If all you have is a house, you can do a deed which transfers your house on death, which is also revocable, which is a good alternative if you don't have enough assets to have a trust. And a trust costs like between $1,200 and $3,000, depending on how complicated it is. So what happens if you don't plan? Very stormy weather ahead, and good thing to do is to plan. Now, so I gave you the wrong PowerPoint. Okay, I'm going to go over with you the power of attorney for healthcare real quickly because it's very, very important. Okay, the power of attorney for healthcare is another document which talks about giving your agent authority to make healthcare decisions for you. Like I said, it's a pretty low threshold of capacity to sign the document. And the power of attorney for healthcare lets you choose a person to make healthcare decisions for you. It could be your spouse, it could be your child, it could be your neighbor, it could be your friend, it could be anybody you want. But what you do is you put your name as agent, Janet Morris, appoint Alex Rabrinovich as my attorney-in-fact for healthcare decisions. A power of attorney for healthcare and a power of attorney for finances cannot be in the same document. They have to be in two separate documents. Another word for a power of attorney for healthcare is an advance directive. I'm sure many of you have an advance directive because every time you go to the doctor now, they ask you, do you have an advance directive? And they want to put it in the medical record, which is a good thing because if something happens to you in your medical record, it will say who has the power to make healthcare decisions. And when I talk about healthcare, and the law talks about healthcare decisions, it means healthcare decisions that include surgery, medication, where your provider, what hospital, what doctor, and it also includes the decision to accept or refuse nutrition and hydration at end of life. And that's where most of the end of life decisions get very sticky, okay? So you want to choose someone who's your agent for power of attorney for healthcare who is going to make the right decision for you. Now, in your power of attorney for healthcare, you can say, I don't want X type of treatment, or I do want Y type of treatment. But most of the hard decisions come down to, do I want artificial food and water at end of life? So if I can't swallow, do I want a feeding tube? If I can't swallow, do I want to have intravenous feeding or intravenous water and fluids? So it's going to really depend on what your condition is. Did you just have a stroke at age 50 and you need those things to get over the hump? Or are you 99 years old with dementia, et cetera, and this is your body just naturally shutting down? So do you want interventions at that stage or non-interventions? So you can be very specific in your power of attorney. You could say, I do not want life-sustaining treatment provided to me if I'm at end of life, and the treatment would only serve to prolong the moment of my death. So in the power of attorney for healthcare that I normally use, there's a box that says that, okay? So if I'm so ill that this intervention is only prolonging my life, I don't want it, you can initial that, and then that's what serves you. You could say, no matter what, do everything for me to keep me alive at all costs, and then your agent will do that. If you say nothing, your agent decides what to do, and presumably your agent you've chosen because they know you the best and they know what you would have wanted. In my opinion, it's better to have some direction to your agent if you really believe that if the burdens outweigh the benefits of treatment, you don't want it. You can say that because it relieves the guilt from your agent. They always tell me they feel like if they don't have a direction from their agent, they feel like they're playing God and they don't know what to do. So if you can possibly share with your agent either verbally or in writing what kind of treatment you want at end of life, that is the best thing possible. Again, power of attorney for healthcare is revocable. You've heard of 5 wishes. You've heard of the California Medical Association form. You've heard of let's see, Kaiser has their own form. Cedars has their own form. They're all very similar, okay? You could use any one of them. They're all legal. Just, it's a good idea to do it. And you can, again, revoke it. The last one in time is the valid one. So if you just write a new one, it automatically revokes the old one. Okay, so I'm going to finish there. I thank you for everything, your attention, and we're going to go back to questions now.
Okay, thank you so much, Janet. We have
Okay.
questions here, and I'm going to unmute you. Our very first question will be from Jeanette. And Jeanette, I'm going to unmute you, and feel free to speak to us.
And my first question was, why does immediate power of attorney stop if you become incapacitated?
Why does the
power of attorney or immediate power of attorney stop? Was that
okay.
immediate?
No, it's the power of attorney. If it doesn't have durable language, if it's called a general power of attorney and it doesn't say, this power of attorney shall survive my incapacity, those magic words, if it doesn't have that, then it stops just by operation of law, okay? It doesn't exist beyond your incapacity. So if you're thinking about planning for the future, you should only think about doing a durable power of attorney for finances.
Okay. Jeanette, do you have any follow-ups? Jeanette?
Talking about finances, with the way things are going now, everybody is putting things, paying their bills online. So how's that person going to be able to get that access?
Well, the person who's your agent under your power of attorney, if they take their power of attorney to the bank and present that, the bank will validate it, make sure it's okay. And then the agent under the power of attorney will create its own password and get access to the bank account just like the customer. So the agent stands in the shoes of the principal. So whatever the principal could do, the agent can do. And that's part of there's a probate code section that says that.
Okay, thank you, Janet, and thank you, Jeanette. If there are any further follow-ups, please post them in the queue, in the chat, and also they'll be responded to after the meeting. We are going to move on to our next question. I hope she's still with us. It's Sherry Ann. So Sherry Ann, we just got a text from you that there was Sherry Lynn, pardon me, Sherry Lynn. Please go ahead. Sherry Lynn texted us that there was an earthquake where she was, a 6.0. Oh, there, Sherry Lynn, are you with us?
Hi, good morning. Hi, how are you? We're well. I'm in the high desert, so who knows what's shaking out here. Anyway, regarding the, we're talking about the power of attorney. I've heard of people changing or wanting to change it after they've given someone the power of attorney, and then the person who has the power of attorney say they're, you know, still not capable of making that decision because they're incapacitated or something like that. Have you heard of those cases?
Yes.
What, you know, what can you do if you're already, you know, hospitalized or whatever, but you still want to change it? And then how do you do it?
That's a very good point. Okay, so one of the things about that I should have said at the beginning is every adult is presumed to have capacity. So the person who's making the power of attorney and revoking the power of attorney is presumed to have capacity. And it doesn't really matter what the agent says. It depends on what the principal says. Now, if the agent wants to protect the principal, because let's say the principal really is incapacitated and is giving their money away and hiding it and throwing it away and giving it to scam artists, then regardless of the power of attorney, the agent would have to go to court and file for conservatorship. So if you don't plan, or if you interrupt your plan because you're so incapacitated that you don't really know you're incapacitated, people around you will have to go to court and get a conservatorship and prove that even though you had a power of attorney and you gave it to the agent, you've now revoked it and you really need it. So the judge would have to get all the information. There would have to be an attorney provided for the incapacitated person. There's a probate investigator. So there's a lot of checks and balances, but sometimes that has to happen, that even though we do all our planning, we can interrupt our own plan and then we have to go to conservatorship. And if we don't have a plan at all and we become incapacitated, somebody might have to file for conservatorship. And that also takes a long time and takes a lot of money to do. So thank you for your question.
Thank you, Sherry.
Thank
Any
you.
follow-ups, Sherry Lynn?
No, that clarifies everything I wanted to hear. Thank you.
Thank you. Great. We're going to move on to Janet next. Let me pull you up here, Janet. And you should be unmuted. And are you with us, Janet?
Yes. Hi, how are you? I just had just a general question or statement, I guess. Is early on in the presentation, you were mentioning that, you know, if you have a joint account or if you have a power of attorney versus a power of attorney on an account at a bank, the power of attorney has to act in your interest and has to do, and I guess my general point is they could act inappropriately, but it would be illegal if they're power of attorney versus a joint owner. If they're joint owner, they could take all the money and they've done nothing illegal. Right. Or, you know, but it just wasn't, you know, it's just they could still do things, but it's not appropriate.
Right. So power of attorney, a joint owner doesn't have a fiduciary relationship with you or responsibility to you. Agent under a power of attorney has a fiduciary relationship to you. So if somebody thinks that you're misusing your power of attorney, they could go to court and try to revoke the power of attorney. Or in a conservatorship, they would revoke the power of attorney, the judge would. Okay. So it's always, I mean, if it's not your spouse, for example, if it's somebody else, it's probably better to use a power of attorney or have the power in a trust and have them be trustee, because then they are held to a higher standard of care. So they have to do things for your benefit, not for themselves. They can't unjustly enrich themselves. Okay? They have to do things. They can pay themselves for, you know, running around for you, you know, a normal wage. It could get reimbursed for that, $15 an hour for going to the bank and doing everything. Definitely, that's what corporate trustees and public guardians and other conservators and other agents will do. You know, private professional fiduciaries will charge for that service. So even a family fiduciary could possibly charge for that service unless you say you have to act voluntarily.
Mm-hmm.
Thank you, Janet. Any follow-ups, Janet?
No.
Okay, thank you. Then our next up is Crystal. Crystal, feel free to join us.
Okay, hi Janet. I basically want to ask you, how come, can I personally prepare my own living trust?
Yeah, so just like the other lady that I was talking about, you could, but I don't recommend it. because trusts are a little bit sticky, and sometimes there's tax issues that you want to be aware of. It's not something I would recommend. Like I said, there are some good people that will do it for a pretty reasonable fee, like $1,200, which I think is very reasonable.
Okay. Also, I had another question. Okay, you had mentioned in the presentation about with regards to having a living trust. Like I have a house, for instance, and you mentioned if you have a home and car, and then you said that there were some items that are automatically, I guess, transferred into the will. And you know, and from my viewpoint, because I had a will prepared years and years ago before I purchased my home, but I thought that having a living trust would supersede me having a will, because I know about things getting tied up in probate, which I wouldn't want to happen. But then you made a statement that I would need a living trust and a will.
Yeah, so the living trust is for everything that's in the trust. So you need to transfer things into the trust. Okay, first of all, when you have a living trust, some attorneys actually go the extra mile and they prepare all the paperwork to put everything in the trust, like the house and the car and the bank accounts and the stock accounts and everything like that. Sometimes they don't. And if you never fund your trust, then it's useless, okay? But what they also will do is they'll prepare a trust and they'll prepare a will. And the will is called a pour-over will. And the beneficiary of the will is the trust. So anything that didn't get in the trust before your death will go into the will, right? It will go through the will and then back into the trust, because the beneficiary of the will is the trust. So that's called a pour-over trust. So any estate planning attorney will know this, okay? But if you don't have a trust and you just have a will, anything you own, okay, that doesn't have a beneficiary like a bank account, could have a beneficiary, maybe it doesn't. If there's assets that are in your own name when you die, they have to go through the will and then to your beneficiaries, and that goes through probate. So you want to avoid that. Right. How do you avoid that? You make a will. You go to an estate planning attorney and you do a will, a trust, with a pour-over will, a power of attorney for healthcare, power of attorney for finances. That's the general package.
Okay.
And then you look at it. You don't do it 20 years and then never look at it. You look at it every so often to make sure that it's still what you want.
Okay, thank you.
Thank you, Crystal. And next we are going to move on to Son. One moment, Son, and I will unmute you. And here we go, sir. Son, are you with us? Can you hear us, Son? Are you still there, Son? So for the moment, we're going to move on to Dirk. And Dirk, are you with us, Dirk?
Yes.
Go ahead, sir.
Yes, first of all, I have to start off with periodically looking at it. That's what I'm doing right now. I thought I had a living trust, but it's a durable power of attorney, and it's my last will and testament. And I had this question because I wrote a note down. After we finished with our attorney, I live in Arkansas, but I have rentals in California where I grew up. And I wanted to leave certain things to my son, home to my son, home to my daughter. But as we were finishing up, the attorney, according to my notes, said California deed code he wasn't sure whether California deed trust or deed code allows for that to be done. And that's the only note I have. So
okay. So there is no such thing as a deed code. It's the probate code, okay? And in a living trust, you can leave you can leave your house to one person, you can leave your rental to another person, you could leave your cash to another person, you could do it however you want. And I highly, highly recommend that if you have more than just your house, okay, and even if you just have a house, that you have a living trust. Now, the alternative to that, if you only have a house, you could do this transfer on death deed, which is going to avoid probate for that house. So you write the deed today and it transfers after death. It it doesn't actually transfer today when you write the deed. So the transfer on death deed is for your house only, but you, because you have rentals, you have a house, and you probably have some other assets, maybe stocks, maybe IRAs and other things, you should definitely talk to an estate planning attorney in California or in Arkansas and get everything together, okay, and make sure it's all correct.
Okay, and it's been since 2010. So I do need, in addition to the final will and testament, a durable, a living trust. In fact, I thought it was a living trust.
You have the durable power of attorney. Make sure the agent is still who you want. Okay. You should have an advance directive also for your health care.
Yes.
Okay. And then when you go to the attorney to do the living trust, they will also probably do a new will, which is called the pour over will, which will circle everything back into the trust.
Okay.
If there's anything that's outside of the trust when you die. Okay.
All right. Thank you very much.
Okay.
Thank you, Dirk.
Good. I'm glad you asked the question.
Great. We have a question from Sohn. I'm going to read it. And the question is, a will versus a living trust, the differences, and which should I get?
Okay. So as I've been saying, you probably need both. But a living trust is when you have, some assets, okay, that you have. So your house, maybe a rental property, stocks, bonds, things like that. And the living trust will manage, your trustee, you or your successor will manage all of those things during your lifetime, and then on your death will pass them to your heirs. On your death, not everything has been put into your trust usually. So you may have another piece of property that still has your name on it, or that you inherited that isn't even passed down to you yet, or other things that you've inherited or you've worked for and gained, bought, that are not in your trust. So therefore you need a will also. If you don't have a trust, you should have a will. Okay, so if you only have a few things, okay, and you don't have enough assets or property to put into the trust, you should still have a will. So the bottom line is everybody should probably have a power of attorney for healthcare, power of attorney for finances, and a will. And the people who have a little bit more assets should probably also have a trust.
Okay, thank you. And any other follow-up questions, please post in chat, and those will be forwarded to Janet. And there'll also be an option Stephanie and Alice will explain about where to send questions. We're going to move on to Eugene now. Eugene, let me just unmute you here. And are you with us, Eugene? Eugene, are you with us? Okay, Eugene, if you hear me, you can check in. We are going to go to Mark. Oh, yes, Eugene. Good. You're there, sir. Please go ahead.
Yeah, you didn't unmute me, I guess. Okay. I had to unmute myself. If a person has a living trust and a will within the trust, how long should it take for the estate to be settled?
So if there's a living trust and a will, like I said, the will is probably a pour over will, where anything outside of the trust will then go back into the trust. It does not have to be probated, probably, and the administration of that trust probably takes 6 months. You should still have a lawyer administer the trust so that everything is done correctly, your creditors are paid, and everything goes correctly to the beneficiaries of the trust.
Okay.
All right?
Okay.
So versus like,
it should be short, but yeah, I know a case where it's already almost 4 years. So
in a trust administration?
A trust and a will, yes. So it's I don't know. It's the lawyers and the trust and the trustees, so that are.
Well, I can't account for, there's a lot of that goes on. And if you ever want some entertainment after the COVID crisis, go down to the court and sit in the probate court for a day, and you'll see some pretty interesting things, including will contests, conservatorship contests, all those things. Very, very interesting.
Thank you, Eugene. Any follow-ups before we move on to our final question? Eugene?
Oh, no, I mean, I don't want to get into it. It's an actual family member, so I don't want to get into their estate, but it's just horrible what's happening with it. So I may ask her later if she wants to give me.
Okay.
Thank you, Eugene. And we'll post that contact information. Now we're going to move on to our final question of just today on our live chat. And Stephanie, Alex, and Crystal will explain to you how to ask questions after. And that is Mark. Mark, I am unmuting you. Are you with us, Mark?
Yes, I am.
Please go ahead.
I had a question. I just had all the documents done by a state attorney for myself and my brothers, and I have copies of their doc and they have copies of mine. I just wanted to make sure if once I need it, I can go in with a copy and it's honored. I don't have to have the original docs.
So for a will, you have to get the will certified. I think you must in the trust administration have the trust certified as well as being accurate. I don't think you always have to have the original. I think a copy is probably okay. But as you know, sometimes there's will contests where somebody will come up with a superseding will or trust that that the court has to administer if there's some problem with it, or if somebody contests it. As you know, when you pass, notice has to be given to all of your relatives and to all your creditors, so that if anybody does have a superseding will or something, that they can come forward. And if any creditors need to be paid, that they could put in their statement that they need to get paid. So I think a copy is okay. Probating estates is not my area, but you could certainly ask the attorney who prepared that. I think that would be a good question for that person.
Great. Thank you very much.
Okay.
Mark. And thank you, Mark. And that is the end of our Q&A, but of course, your presenters coming up now, Alex, Crystal, and Stephanie will remind you about how you can ask further questions. I'll be standing by. Thank you. It's all yours, Alex.
Well, I hope everybody enjoyed the presentation. Again, I know there's a lot of information, and we will be posting the recorded presentation on our website, as well as sending out the PowerPoint. Also, through the chat, we sent a link to our new YouTube channel, and we have some previous presentations by Janet from our other events, as well as our other presenters on various topics. So if you have some time and you don't mind accessing YouTube and possibly getting lost looking at all kinds of videos on there, check it out. There's a lot of really great information that if you haven't been able to attend our events in the past, you can definitely see some great presentations. In terms of how you can get more information or get your questions answered if they haven't been asked, in the chat section, Stephanie sent out a note saying that you can go ahead and send your question to lacerswell@lacers.org, and we will get those questions to Janet, and we will send you a collected, we'll gather all the answers and send out a collected FAQ for everyone. Stephanie, Crystal, is there anything more on that?
Okay, well, yes, thank you, Alex, and thank you so much, Janet. I feel like I have I feel like I have as many questions as our participants on here today, but I just have a few announcements, as I've stated in the other presentations that we've had. As you know, the Lacers Well team, we're looking for champions. Maybe some of you have already reached out to Stephanie. We do have a champion volunteer phone bank that we have established at this point in time to reach out to our other retired members who may be going through different things, may be feeling isolated during this COVID-19 situation right now. And so if you would like to participate in assisting us with calling and reaching out, send us an email via the Lacers Well email to Stephanie, and we can get you signed up for that. We also do have an upcoming, some of you may have already received my email I sent it out yesterday, I believe. We will be having our Champion Summit, which will be coming up on August the 13th. Please go through your My Lacers portal to register for that event for our champions. And we also have our own Aging Mastery AMP program that will be coming up in the month of September. So these are some activities that we have that you can participate in, and we definitely look forward to you all logging in and telling some of your other retiree friends to join in and participate. Thank you. Over to you, Stephanie.
Mute. Thank you everyone for your participation, and thank you for staying over a few minutes as well. Just like the last two workshops, I'm going to launch the poll and would really appreciate your participation in the poll. So I'm launching that poll right now. So take a moment and participate in our poll, please. Oh, great. We have some participation. Well, we're getting really great participation on the poll. We're halfway there, so I'll give it another 30 seconds or a minute. We also had someone ask about our Aging Mastery program. Crystal and I and Alex are planning our next, or we're planning to have our AMP virtually for the month of September. So look out for that information as well. A lot of great things coming. After meeting with the champions, we hope to have other activities, virtual activities planned as well. So really some exciting things we have planned for the year. So look out for your emails, check your emails regularly. And you know, we hope that you have enjoyed these workshops as well as upcoming workshops that we have planned. So about 15 more seconds before I end the poll. About 10 seconds. Okay, so I'm going to end the poll.